Welcome home. I'm Marc. I'm joined here today by Cristen Martinez, real estate specialist in the legal industry. She is an attorney for well over 10 years in the Florida market, and it's a pleasure to have you here today.
The pleasure's all mine. Thanks so much for having me.
I appreciate that. And you are a principal of Martinez Law, where you're redefining legal care. Tell us what that means.
Yeah, so part of the whole reason why I started my own law firm is because I had worked in several law firms before, and I never really found a place where I felt that I could practice the way that I thought the law should be practiced, meaning really that, client should be number one. And so in starting my firm, I said, you know what, I need a tagline. Why am I starting this firm? What is kind of behind this whole idea that I had? And I really focused on the word care. So I didn't say we're going to provide excellent legal service or anything like that. Care to me had a connotation of how a doctor or a nurse would care for a patient. It goes beyond just drafting the legal documents or showing up in court. And so in the redefining piece is, I don't know if any other law firms are doing it, but not any law firms I could find were really providing the level of care to clients that I thought they deserved. And so that was kind of the whole reason behind me starting the firm, and that has been our tagline since day one.
I love it. And it does remind me of, an industry where, like health care, where care is important more than just service. So that's really cool. And you are a Florida State Seminole alumni, and thereafter you got your doctorate from Stetson. So what made you go the extra length to go, get a doctorate and not just be content with your Seminole degree?
First of all, go Knowles. So it's my Juris Doctor that I got from Stetson. And really since the 10th grade, I knew I wanted to be an attorney. I took a debate class in high school and really never looked back. So all throughout my undergraduate time at Florida State, I was just, thinking to myself, what can I do to better my chances of getting into law school and being able to get that law degree? And so that was the focus and the goal behind everything I did up to that point. The choice of going to Stetson was really, Florida State is a very fun university, but it's also very distracting. So for my legal education, I thought I would come back to my hometown area, which is the Tampa Bay area, and get my legal degree from Stetson.
City of Champions, and it welcomes you because we need strong professionals like yourself to help protect us, help protect our buyers or sellers, help protect us real estate agents and everybody in the industry. Something I came by when doing some research on you, which was really cool. Of course, it sounds cool, but I want to know more about it. Is it really cool being a member of the Supreme Court, the United States Supreme Court? What does that exactly mean when that's on your belt?
So actually every lawyer that is a member of the Florida bar in the state of Florida is part of that Supreme Court. And so that is a requirement of being able to be a practicing lawyer here in Florida. So the law degree is step one, passing the bar exam, and there's also an ethical and character component to being admitted as a member of the Supreme Court as well. That's what allows you to be a practicing attorney here in the state of Florida.
Very good. And you're also a part of the one of the districts of the federal court in Florida. How much time do you spend in federal court?
Very, very, very little. I got admitted to the federal court, and the way it works is once you're a member of the Florida bar, you are by default admitted in all state courts. The federal courts are separated out by district, and you have to apply separately and be admitted separately to each of the different district courts in order to file a case or represent a client in federal court in that district. And so the middle district of Florida covers the Tampa Bay area where I'm at. And I actually got admitted specifically for one case. It had been in state court litigation for 4 years. The defendant in that case had filed for bankruptcy. And so in order to appear in the bankruptcy court, which is federal, I had to become a member of the federal bar for that district. So it was really all for one client in one case, and that has been the extent of my time in federal court. We don't really see it a ton in the real estate space.
Now here at Home with Marc, we focus heavily on the real estate industry, and that's a very heavy part of your practice. So, one thing I wonder is, what sort of trouble do you typically see real estate agents getting themselves into as a pattern over your years?
By far, the biggest pattern I see in that area is real estate agents are oftentimes practicing law without a license. They are drafting contracts, they are freehanding contract provisions and addenda, and they are not allowed to be doing that. Most agents that you talk to will tell you, I do that all the time. I didn't know I wasn't allowed to. As agents, you are allowed to fill out the blanks in the pre-printed standard form contracts. You are not allowed to freehand or draft your own contract provisions, and that applies to the addendum and the amendments that we see are so common in our real estate transactions here.
So are you referring to closing date extensions, inspection date inspections, and those simple forms that we fill out all the time? I may or may not be guilty. I will nor confirm nor deny, but let's say that I had to extend the inspection period for my buyer. I can't fill the addendum out. I can't do that myself. Or where's the line drawn? Help us out with that.
So the line has been made very clear by the Florida Supreme Court. The line is that as agents, you can fill out standard form templates if the contract has been approved by the Florida Supreme Court. So that's going to cover here in Florida your CRISP contract and your FAR contracts, or the template or the contract has been drafted and approved by an attorney. So typically what I recommend, because it's not practical to run to an attorney's office every time you need to extend a closing date, typically what I recommend, and most brokers do this, is to have an attorney draft template addenda for items that you see come up in transactions often. In that way, you have templates that you know are well drafted that you can go ahead and utilize for your transactions. Technically, the answer to your question is no, you're not allowed to do something even as simple as that.
Okay, well, that's fairly good to know, and that's why we're here. This program is very education based, so it's nice to know something we didn't know before. I think a lot of real estate agents might be doing something that they're not supposed to be doing, based off what you're saying.
Yes, and a lot of what I see are things that agents could have prevented. So a lot of what I see in my practice are disputes between buyer and seller and lawsuits that result from those disputes. The majority of those disputes could have been avoided had the contract been clearer or had the parties been advised properly about what the contract said. And so in starting my law firm, one of my main goals and passions is let me educate these real estate professionals so that number one, they're protected, but number two, their clients, their buyers and sellers are less likely to find themselves in these positions where now I have to call a lawyer and either sue somebody or defend myself because now I'm being sued.
Well, I want to bring up a case to you that happened in Sarasota in recent years, and I want to get your take on it. A prominent Sarasota real estate agent, well known in Sarasota, working for a very prominent brokerage. Both of them were sued. Both the agent and I believe the brokerage were sued over a $4.8 million transaction where both the buyer and the seller side both sued this agent because what they had alleged was that he was manipulating the deal so that the seller would choose a buyer's offer that he had found himself. So he would be able to get a bigger commission, get a buyer and a seller side commission. And the way that they found this out is really interesting. It's kind of a real estate agent's worst nightmare. Even if they're acting ethically, this is something that you just don't want to happen. So the reason they alleged that was because the buyer, a buyer, not the one who was selected, a buyer put in an offer with an escalation clause that goes up to $5 million. Okay. The offer that was chosen was for $4.8 million. Okay. That $5 million offer also included an option to waive inspection. So it was a really good offer. $5 million and waiving inspection. They chose the one that was $4.8 million. And when the buyer, who seems to be very savvy, found that out that it was pending for $4.8 million, he wanted to see if he can put a stop to it and put a better offer in and make that his deal. So he went to the seller's house. He went right to their house, basically saying, hey, I'm willing to offer $5.3 million if we can put a stop to this shenanigan that you've got going on with this buyer, and you're going to make an extra $500,000. Take my offer. I already offered you $5 million. Whoa, you offered what? My agent didn't tell me that you put an offer in for $5 million. Oh, so now you've got seller and buyer standing in the front lawn having this interesting conversation that the real estate agent, who may or may not have done this intentionally, has no idea this is going on. So next thing you know, he's being delivered, him and his brokerage are being, served a lawsuit. And they went after a lot. They went after like $30,000, commissions, damages, and all kinds of stuff. So when you have a buyer go under contract with your seller, I digress. When you have your seller go under contract with a buyer who you found, and now you're representing both, this is a two-pronged question. Number one, what's your take on that situation? And number two, how do you decide who and when you're looking after whose best interest? Like who, it's really a very much of a gray area, because I've represented both sides, but it was just so easy and there were really no negotiations happening. It was just here's the offer, I accept, we'll see you in 20 days at closing, and that was it. But it can be much more complicated than that. So what's your take on that? First, on that story that did end up becoming a very public case. This isn't something that that everyone doesn't already know about. So you being a real estate lawyer, you've probably seen things similar to this, but this one specifically, what's your take on that?
So this one is pretty extreme. And when I talk to agents, naturally in advice that I give, kind of like some of the advice that I gave earlier regarding the contracts and what you can and can't do as an agent, a lot of agents get very uneasy and they're scared and they don't want to be sued. And I always tell them, you have to do something pretty egregious to get yourself sued or to get your license suspended or anything like that. This falls into that pretty egregious area as far as the agent's conduct here. The fact that, and I think a lot of agents have this kind of false sense of security that, well, the buyer's agent cannot go directly to my seller. So whatever I'm telling my seller, the buyer and their agents are never going to know, because the agent has to go through me. They can't go directly to the seller. They fail to realize that the buyer can go directly to the seller, even though the agent can't do that. So while it doesn't happen often, that is a possibility, and agents should be aware of that possibility. Here, we have an agent that presumably, and I don't know this for a fact, I'm making an assumption based on the facts here, did not relay this buyer that wasn't chosen, this $5 million offer, to their seller. That is a breach of duty all day long. As an agent for both seller and buyer, your duty is to, you're not allowed to protect one party's interest to the detriment of another. So you can't protect the seller to the detriment of the buyer, or vice versa. And so your duty is just to take the information and relay it to the other party and let the parties decide whether they want to accept, counter, what have you, as far as that goes. But the agent's conduct here, if in fact he or she did fail to present that $5 million offer, because that would have meant less commission for him or her, that is self-dealing. That is very egregious. Not a good situation to be in for that agent.
Indeed, it's not. So circling back to if you're representing both buyer and seller. So let's say you have a house on the market. I am the listing agent, and I've been working with this seller for 40 days because the market slowed down. It's no longer on fire. It's just simmering, as I like to say with the Florida market. So now, 40 days in, we get an offer from somebody, from a potential buyer who I've procured. So now I do have the right to get my contractually agreed commission that I agreed with my seller. If I find the buyer, this is, the commission you'll pay, as opposed to if we cooperate with another brokerage. So that happens 40 days in. Now that 40 days, that could have been 2 months, it could have been 60 days of a relationship, those 2 weeks of building the relationship and the listing, and then 40 days of it being listed. Now you have this relationship with the seller. They trust you. You've been looking out for the best interest. You've been telling them, hey, you shouldn't take that offer. It's no good. And hey, this is my recommendation. And hey, they're saying this, but really this is what's going. You're giving them all of this insight, and they're used to it. Now all of a sudden you're in a situation where you're representing both sides. how can that go right? How can you make that go right is what I'm really asking.
So I think the key is going to be to educate and to have open communication. So the seller in this case needs to understand how the relationship changes in this circumstance and what they can expect moving forward. Having loyalty to one party over the other does not mean that you cannot provide insights and advice based on your expertise and your experience as a real estate agent. It just means that you cannot advise one party to do something that would be to the detriment of the other. So, and the examples that come to mind would all constitute legal advice anyway, which shouldn't be done no matter what the relationship is. But the key is just to have open lines of communication, to submit all offers made, all counter offers made, whether you believe the other party is going to accept them or not. You have to communicate all offers, and to just educate and communicate openly, I would say, is the biggest takeaway here. But nothing would prevent you from using your past experience and your expertise to give insight and recommendations.
Yeah, it just seems like something maybe not for the green or rookie real estate agent to get into, because it can cause an issue and they may not know how to handle it. If that seller who I've been representing for 40 days, on day 41, now I'm representing both and they're asking me for advice. I mean, now I feel like I have my hands tied and I'm in this weird gray area.
It can be a gray area, and referring back to the newer or the greener real estate agents, I think it's very important to have a broker that is going to mentor you, or another agent that is willing to work with you on the deal. I think any deal is dangerous for a very new and inexperienced real estate agent, because while most deals, I would venture to say, go through without any sort of issue, there is that risk, and there are going to be those times where something unique or very complicated comes up. And if you're in over your head and you're just, making guesses here and there on how to handle things and what to do, that's a very dangerous place to be. So I would really focus on having a mentor, whether it's your broker or someone else within the company, or even partnering with another agent, even if that means giving up some of your commission.
Yeah, and I couldn't agree more. I work at Keller Williams, and that's one of the actually, it's the best brokerage you can work for. It's the best company you can work for in terms of training and having those mentors always there and ready for you. So I couldn't agree more. I think it's really important. After a few years of that, if you have other ideas and you're an entrepreneur, go for it. But I think those first few years are absolutely critical to have yourself surrounded by people who have been in the business maybe longer than you've been alive, to be safe. My wife and my partner, Lala, she proved that she's a professional real estate agent, because I think she got sued in her first month as a licensed agent.
Oh, no.
For $6. Yes, for $6. But we settled for $10 out of court. So what she did is she was putting her business card on people's windshield outside of a community center to get her brand new business name out there. Well, somebody didn't like it, and they called her and said it left a spot on their window and the product's going to cost $6 to fix. And we said, look, we understand, we're going to pay for that, and we're going to pay for damages. So we cash apped him $9.80 because they take 10%. So that's what he got. He got $10. So we got sued for $10, learned a lesson, haven't been sued since.
Well, that was very generous of her. And I'm glad that's been your only kind of run-in with the legal system in that area, because most of the times it's for a lot more than the $6 value. Absolutely.
And that's another important thing about working with a really good brokerage who offers E&O. Error and emissions insurance, and it's not that expensive, to pay that little bit and be covered for $1 million or a couple $1 million had anything, gets out of hand at some point. That's really important too, right? Where do you see that helping people, and where do you see it not helping people?
So I definitely think it's a great idea and a requirement, in my opinion, if I were in that position. As a new agent, I think taking less money or profit or commission is going to be worth it all day long, to have the support of, you have insurance backing you, you have the mentors, you have the training and the education. All of that is going to be so much more important at the beginning than just focusing on the bottom line and, prioritizing that, because it takes not very much to have a transaction go wrong. And when it does, the consequences can be catastrophic. I had a case in my law firm last year where this was a commercial agent. She was, I think 3 months in. She got her license in January. I think the transaction happened in March or April. She was a commercial agent for 3 months, but this happened to be a residential deal. So it was her very first residential deal, and it blew up, and she's sitting for depositions, and she's going to court. And I actually felt terrible for her. I was on the other side. She, made some mistakes for sure, but I felt terrible for her. She didn't know any better, and she didn't have the support maybe that could have prevented something like this. So I think that support, I think insurance for sure will provide that peace of mind and that comfort. And then in the event something does go wrong, you have coverage for that. But I would caution agents to not use that as, something that makes you take risks you otherwise wouldn't take, or, fail to put in other precautions and other protections just because you're thinking, well, if I get sued, I have insurance, so I'm not going to have to come out of pocket for anything. I wouldn't look at it like that, but I definitely think it's a necessity.
Yeah. And then, it's just good to have insurance. It's kind of like having a car or a house without insurance. Things happen, and sometimes you don't have that to cover it. And I can imagine there are 100% commission brokerages who are not offering that to you. And that can leave you in a really, really tough spot. I want to circle back to something a little bit more personal to you, if that's okay.
Sure.
And that's, something that I'm not going to speak on too much, but women empowerment, being a strong woman in a, what used to be, I wouldn't say now and today, but used to be a male-dominated industry. I don't know if you can agree or not with that. I'm not expecting you to, but that's just my perspective. I believe, traditionally very male-dominated. But after breaking into law, it wasn't long before you opened your own law firm, before you opened your own practice, Martinez Law. What pushed you? What's your pedigree? Do you have family that were in the industry, or if not, what was it that pushed you to go so far? And I'm not trying to say there should have been a ceiling or anything like that. Don't take the question like that, but so quickly, right? So far, so quickly, where a lot of people maybe feel that they may not be ready for that kind of responsibility, but clearly you were. About a decade later, here we are. Martinez Law still a very prominent source here in the Florida market. So early on, think back, a decade ago, what was it that pushed you to say, hey, I'm not going to work for a law firm. I'm going to be the law firm?
So that's an interesting question, because I never had a desire to be an entrepreneur. I never had a desire to open my own business and do anything of the sort. In law school, my idea was I'm going to go work for a big fancy law firm, and I'm going to work 24/7, and I'm going to become a partner, and I'm going to be really rich. That was my plan. And so I did go work for the big fancy law firm, and I didn't work 24/7, but I worked very, very long hours. I didn't make near the money I thought a lawyer would make working those hours, but it really came down more to the treatment of the clients and the priority of the law firm and things like that. And so I went and worked for another law firm that I thought would be better. And I saw a lot of the same issues. So then I went and worked for a very small law firm, thinking maybe it was just big law that was that way, and a lot of the same issues. And so I realized, if I'm going to do this right, I have to do it myself. And what I did was, I was single at the time, no children. And so all I had to do was take care of myself. And I said, how much money do I need to make sure, I don't go into foreclosure and I can pay my bills? And it wasn't a very large number. And the amount of clients I needed to hit that number was not a very large number either. And so it was really just having, the passion for the clients, first of all, but then the confidence just to say, I can do this. If I put all of my effort and all of my energy and resources into this, I can do it. And I had a cell phone and a laptop, and that was my law firm when it started back in 2015.
Wow, that's incredible. That is quite an amazing story. And that has me wondering, what was that issue that you saw 3 times in a row, 3 different law firms seeing the same issue over and over? What was it?
So it was a lot of the stereotypical things about lawyers, not getting back to clients timely, not moving clients' cases along as quickly as they should be because maybe they're not as high of a dollar value case as other clients. With Big Law, what I really saw was, the bottom line was the priority, not the client. And I was asked to do things that made me feel very uncomfortable. And I thought I had to do it in order to keep my job.
Now,
and so,
if I can interject,
Sure.
is that in the billable hour world?
Yes, that is in the billable hour world. And there were very high, very strict billable hour requirements. And it was basically, hit the billable hours at all costs, whether you have to duplicate work or whether the work's there or not.
Wow.
You hit the billable hours at all costs, or, it wasn't said your job is in jeopardy, but that was certainly the feeling that I had.
So that's a culture that we hear a lot about in law, is the billable hour. And what if I'm at home and my lawyer is in their office and they told me they worked 9 hours? How do I know they worked 9 hours? And what did they work on? Why does it take 9 hours first of all? Because that seems like quite a long time to work on a couple of pieces of documents. And I digress. I don't mean to downplay at all how difficult and challenging law can be, especially when you're writing memos and all kinds of things that take a lot of time, especially in that part. But transitioning to real estate law, not as many things are billable hours, a lot more flat fee services. Am I right?
So I still think the most common way to charge in the legal industry and in real estate law is the billable hour. And your point is exactly right. As a client, most clients don't understand what goes into drafting a motion or what kind of preparation goes into a court appearance. So to me, while 9 hours is not ridiculous at all, clients just don't know. And so they feel frustrated when they get the bill because in their mind, they're expecting a bill for 1 hour when it took you 9, even if it was 9 legitimate hours. So actually last year, my firm moved completely over to flat fee, and why I like that setup a lot better, and it's been working out great for us and for our clients, is the goals of the lawyer and client are now aligned. So under the billable hour model, the longer the case takes, the more money the lawyer makes. So the lawyer would like to see the case drag out as long as possible because that's where they make their money. The client, of course, wants their case to be resolved as quickly as possible. And so while lawyers have an ethical duty to, act in the best interest of their client and move cases along as quickly as possible, if you're a struggling solo and you have to pay bills to keep the lights on, I'm not saying that most lawyers do this because I don't think they do, but I have seen lawyers intentionally drag out cases for purposes of increasing their billables, which is very unfortunate to see. And so with the flat fee model, the faster I get the case done, the more profit I'm going to make because I still get my flat fee, but now I can move on to the next case sooner than if I were to drag this case out. And so it really aligns the priorities of client and lawyer, and the client sees the fee up front. So there's no misconception about how much this is going to cost or what the client thinks it should cost versus what the lawyer thinks is reasonable. It's out there in the open up front, and if the client doesn't like the fee, they don't have to retain that lawyer.
I wasn't expecting that because you started off defending the billable hour, and I was like, okay, well, yeah, that's her industry. I would do the same thing. And then you're like, but we just transitioned to all flat fee. I'm like, awesome. Well, that's really good. And and this is just my harebrained opinion. I think that's amazing because that is something that clients love to see, I'm sure, is to know what they're going to pay up front for, especially in law. It's very intimidating to hire a lawyer based off of a lot of things, and usually one of the top things I would say would be the cost and not knowing, well, okay, I mean, how long is this going to take, and and how much is it going to cost? But that's really cool, and I'm glad to hear that. Martinez Law, very good. And before we forget, I know we'll probably put a lower third earlier in the episode, but what is the best way to get a hold of Martinez Law? We're not done with the interview, but I just want to interject that now right in the middle of the content. What's the best way to get a hold of the law firm if they do need help with real estate or other
Sure. So our website is going to be the best way for that. That's going to have our email address, our office number, as well as a direct contact form on there. That is Martinez Law FLA, as in Florida.com. We're also on all of the social media platforms as well, but the website will have all of the direct contact information for you.
Perfect. Okay. And circling back to an initial question we were just touching on, it was about starting your own law firm. Something that I sort of touched on, but I didn't really go into it. Wanted to give you a chance to see if you wanted to go there or not, but I'll just kind of take us there. And I'm just going to put it out bluntly because I can rant forever if I want to. How hard was it to break into an industry as a female at such a young age and opening the law firm on your own and really breaking in and getting the respect of your peers?
So I think that as a young female attorney, it is very hard. If you look at the numbers right now in Florida, there are more female attorneys than male in numbers. However, I do still think it's a male-dominated industry. A lot of those female attorneys are either leaving the practice when they have children or they're going part-time when they have children. And so when you look at partners and kind of upper-level positions, that is certainly male-dominated. And I did earlier in my career, so mostly when I was working at law firms, I did experience a lot of, well, are you the intern or are you the secretary? Nope, actually, I'm your lawyer. Sorry to break it to you, type of comments. And, sometimes when you get male attorneys on the opposing side of a case, they, call you up on the first day of the case and say, hey, I've been practicing since before you were born. And, I'm sure you don't know this yet, but here's what the law is. And here's how the judge is going to rule. And
trying to take advantage of your naiveness, even if it doesn't exist, to try to get you to settle and not even go into the courtroom.
100%. And that was a huge mistake at least in my case, because when I have somebody that doubts me, it makes me want to win that case even more. And so I will over prepare, even if I'm not billing the client for it, just to show you that I do know my stuff and I'm just as capable as you are. And so I think, I also look very young for my age. So I think the age and the female aspect did elicit a lot of those types of comments. I think in starting my own firm, though, I didn't experience really, at least I didn't perceive any sort of disadvantage or people unwilling to hire me because I was a female versus a male. One thing that actually Lala and I were talking about before we started was, my personality is not what you would think of as the stereotypical lawyer. And so I'm very bubbly and outgoing and casual. I have tattoos. I don't wear a suit every single day. And when I started my own law firm, I made the decision, you know what, I'm going to be myself. And if people want the very formal lawyer with the, law books behind him in his office, then I'm not the lawyer for them, and that's okay. And so kind of having that mindset, I didn't really see or perceive any disadvantage that I had in starting my firm or growing my practice.
I feel like you prepared for that answer. It's like perfect.
I get asked it a lot. I've gotten asked it a lot throughout my career. So,
well, I only ask it because it's so cliche, and I hate to say that, but for the record, I don't in any way subscribe to that, especially in an industry that takes cognitive thinking and takes strategy and the mind. I feel, all humans are equal there in terms of capability and potential. So I don't subscribe to that. I just know that you had to have gone through some trials and some sort of tribulations in regard to that. So let's go a little bit to some law, actual law, things that maybe consumers may be wanting to know, and even real estate agents might want to know. Something that I actually ran into, not personally in my business, but somebody that I know personally just ran into something along the lines of, after a residential home closed and the buyers in that home, within like a month or so, suddenly something that in the inspection checked out, for instance, electrical or plumbing, starts to go absolutely awry. It was fine when they did the inspection, everything was fine, and they did the final walkthrough, everything was working fine. But suddenly, a few weeks, a month into living in the home, it goes awry, and now they want to sue. What ground do they actually have to take any legal action?
So in this case, the only ground they would have is if the issue was something that the seller had a legal duty to disclose. So things go wrong in a home. So if you buy a home and everything's working fine and a month later something breaks, that's the risk of home ownership. There is no recourse for that unless this defect was pre-existing. So it pre-existed either at the contract or the closing. The seller knew about it and the seller didn't disclose it. And I say this with some caution because in Florida, the seller's duty to disclose defects in a home is very, very, very limited. It is very much a buyer beware type of transaction.
Hence the third row, I don't know, in the seller's disclosure.
Exactly. So buyers really are obligated to do a lot of research and due diligence into the property. And I can rattle off the elements that are required for a seller's duty to disclose just to kind of demonstrate to you how limited it really is. So the first element is that the seller has to have actual knowledge of it. The seller, if they don't know about the defect, they can't disclose it. And what actual knowledge means is if the seller had a contractor do work and the contractor knew, that knowledge is not imputed to the seller. We would have to have proof that the contractor told the seller about the defect and the seller did not disclose it. The second element is that the buyer cannot have any knowledge of it. So if it comes up in an inspection report, if it's discussed between buyer and seller prior to closing, the buyer has knowledge prior to closing and they cannot complain after the fact. The third element is that the defect cannot be open and obvious. So it has to be a hidden defect. And what that means is not only it can't be visible to the naked eye when you're physically walking through the property, but this also covers everything recorded in the public record, which is missed a lot. So if something is recorded in the public record, it's on the buyer to do that due diligence and find that information. That's going to apply to permits for sinkhole repair. That's going to apply for any sort of HOA or deed restrictions that are covered. Any permitted work, a roof repair, anything like that that is public record, the seller does not have to disclose. That also goes for lawsuits. Lawsuits are public record. Seller doesn't have to disclose that. And the fourth element is that it has a material effect on the value of the home. So we're not talking cosmetic defects. These have to be major defects, and what constitutes a material effect is going to really depend on the value or the price of fixing the defect versus the value of the home. So that's going to differ based on your purchase price.
Let me throw another variable in there. What if the inspector completely fluffs and misses something really important? For instance, their infrared didn't catch something behind the wall, water damage, or he just wasn't a very good inspector and he didn't catch the fact that the electrical was about to go bad. Can now the buyer who now lives there and has taken on the responsibility and risk of owning a home, do they have any recourse against the inspector who clearly missed something that any trained inspector should have caught?
So home inspection companies and home inspectors do a very good job of protecting themselves and limiting their liability in the contracts that they have buyers sign. There are some more mom and pop type companies that do not have these limits of liability. So the likelihood of being able to go after an inspector in that case is a little bit greater. But typically what I see is the contract is going to contain all of this language about the scope of work and what we do look at, what we don't look at, what we're not responsible for. But the kicker is even if we miss something, our liability is capped at the cost of your inspection. So if they miss a $20,000 issue and you only paid $500 for your inspection, that's what their liability is capped at. Okay. So typically that's a hard claim to make just because of this extremely one-sided language that many inspectors have in their contracts.
I figured they would protect themselves. I mean, those inspection reports and all the paperwork that come along with, registering on a home inspection website, and you're checking all these boxes and you're initialing all these different things. I would assume a lot of that is to protect their liability. Now, still kind of sticking to law and lowering risk for sellers and buyers, or even for ourselves. For me, myself, a real estate agent, if I was in an elevator with you and I said, "Hey, Cristen, give me some free advice before I get to the 20th floor," as a real estate agent to lower my risk and And, just to, what are those few tips in an elevator you'd give a real estate agent to lower their risk and to stay out of court or arbitration?
So the biggest thing that any real estate agent can do is to know that contract like the back of your hand. Typically what we're seeing here are the FAR contracts. You should know both the standard and the as-is versions of that one, because what most disputes come down to is the contract being breached or an ambiguity in the contract if there are amendments or addenda being used that are not properly drafted. That's the vast majority of disputes, and that is a lot of times within the agent's control. Now, if your seller is sneaky and covers up mold and doesn't tell you about it and then gets sued, there's no way for you to prevent that because you didn't know about it. But the contract you should know, and you should also make sure that your clients are reading the contract. And if they don't understand it, they need to review it with an attorney, because a lot of these disputes are people just don't know what they're signing. They're not reading it. They're certainly not understanding it. They're signing it, and then they're proceeding in a way that they think is right, but maybe not be in compliance with the contract terms. And so it really is your duty as an agent to make sure you're having the conversation with your client. It's very important you read this. If you don't understand it, ask me. If I can answer the questions, let's go get you into a meeting with an attorney that can go over this with you and explain all of your deadlines, your obligations, all of those things under the contract.
Very good. So now I want to pivot a little bit to something else that some experts actually claim that there may be some violations of antitrust laws here. And I'm not claiming to be one of those experts in any way. Just throwing that on the table first to frame this. The MLS, multiple listing service. When I want to, as a listing agent, when I want to list a home, a vacant land, or whatever it is on the MLS, I'm not able to submit and publish that listing without entering some sort of amount to pay a buyer's agent if we're to cooperate with a brokerage. Okay. So what I'm getting at here is they're basically cornering you and saying that they're cornering the seller and forcing the seller to pay a cooperating brokerage. Now, again, I'm not claiming to be one of the experts, but I will give my opinion. My opinion is that I think in a fair market, the seller should not fork out $20,000 in commission on like a $300,000 home. Okay, in a fair market, they will pay their seller's agent, and the buyer will pay the buyer's brokerage, because, in essence, I mean that's a lot of money to fork out. That's just my opinion. I don't know the law to back that, but in your opinion, do you feel that there might be any violation there of any antitrust, that they're forcing a seller to pay, to basically you can't list this on our service unless you pay a brokerage? And what those experts, I'll just finish with this. What those experts claim is that NAR, the MLS, and the big name brokerages have all gotten together and conspired to make this part of the MLS system. What are your thoughts on that? And do you think that would or could be a violation?
So I really can't give, an expert opinion on whether that would violate antitrust laws. That is not my expertise, but, and you would know better than me as far as filling out the MLS. Everything in an agreement between buyer and seller is negotiable. And so even though the system is requiring you put an amount in there in order to post it or make it go live, is there an additional comment section where you can say buyer covers their own agent's commission? Because in the relationship between buyer and seller, which is what this is, the MLS listing is an offer being made by the seller, which can be accepted by a buyer, and boom, you have an enforceable contract. So those terms should be able to be customized by buyer and seller in any way that they want. And so one way to maybe get around the system's requirement, because the MLS is not a party to this contract, and so their requirements really shouldn't be able to affect or dictate the terms that buyer and seller ultimately agree to. So I'm not as, like I said, familiar with the system, but if there was a way to put a note or an additional term in there that states buyer covers their own real estate agent's commissions, that's how I would handle that. And then that would, of course, be memorialized later in the purchase agreement.
I feel in the last couple of years when the Florida market was just lit on fire and the sellers were in the pilot seat, I feel like maybe they have missed the boat on that because sellers were still paying commission for both sides throughout that entire, that entire storm that we went through. I think maybe they missed the boat there. That maybe that might have been the time to kind of turn the tables a little bit and get the buyers to start paying their agents. Now it's really hard to get them to do that. As an agent, that would be difficult to sit down with them and say, hey, look, the seller's not willing to pay me. So if you want me to proceed, I'm going to have to negotiate something with you. So that means, yes, they're accepting your offer at $340,000, but you're going to actually have to pay like $350 because you're going to have to pay my brokerage about 10 grand. That's a hard conversation to have with a buyer. It's really hard. But at the same time, on the other side of the coin, it's still, to me, unfair for a seller to have to pay both sides.
Right. And I do think it's a hard sell. It's also, well, the buyer's going to go for another $340,000 home where that's not part of the listing, where the seller is willing to pay that commission. So as a seller, you're less likely to get offers, or you're going to get lower offers. Now I'm only willing to pay $330 since I have to pay my own agent $10,000. So it hurts a seller either way. And I do think that this has been missed in the market. I think it's been done this way by everybody for so long, and people just continue to do or maintain that status quo. But I think if, you as a listing agent, if you wanted to be different and really do this to protect your seller, I do think it could backfire because 99% of everyone else, the sellers are paying those. So that's going to put your seller at a disadvantage of being able to get a fair price for their home.
Interesting. I think it's a conversation to be had. I think that it's a hard sell because it's not the culture that was created. So you create a culture, people get used to it, then that creates a hard sell. But had it always been that way, then there would be some balance, and it wouldn't be such a hard sell. Something that I don't necessarily want to agree with, but it could be true. Our when I say our, I'm not referring to you, but real estate agents. Are our commissions and salaries inflated a little bit? Are we overpaid?
Gosh, I always say I do not envy your job as real estate agents. You all, you have to be available 24/7. You're putting out fires left and right. I've bought and sold several homes on my own, and not on my own. I had an agent, but personally, I bought and sold several homes. And man, you guys work very hard. And so I don't know how many hours per transaction you typically put in, but I don't think that just across the board, you're overpaid based on the 3 or the 6% that's common. You guys work really hard and you deal with a lot of difficult situations, and it's nonstop. With the contract's deadline of 11:59 p.m., agents are negotiating deals until, right up until midnight. I don't do that as an attorney. I'm fast asleep at that time. So I don't agree with the folks that kind of claim, that real estate agents are overpaid. I think you guys work very hard.
One other thing that I appreciate that, and we feel the same about you in your industry, tireless hours, clients who need education but don't want it, and all the things that come along with our industries. And I don't envy your job either. I respect it. Before we kind of start to wrap, I wanted to bring up another sort of not a case, but something that people deal with often. Real estate agents stealing dealers from other real estate agents. What is the take on that? Where is the line drawn there? If, for instance, I'm representing a buyer and then someone just swoops in and says, hey, look, I'm going to give you a better deal on it if you work with me. Are they violating a law, or is it just more ethics?
So I think that falls into the ethics category more so than, that sort of conduct being illegal, unless there is any sort of written agreement between that agent and the buyer. And I know that many agents don't get written agreements with their buyers, which I think is a mistake because it does open the door for conduct like that to occur. Do I think it's tacky? Do I think it's not right? Yes, absolutely. Does it cross that, ethical line that's set by FREC and by other organizations, or does it cross that legal line? I think that really depends on the circumstances. We have our procuring cost standard that we use here in Florida as far as who's entitled to a commission. But from what you're describing, it sounds like we're talking about way earlier on in the process. And at that point, I think it's just bad business versus something more serious that could result in an effect on your license or a lawsuit.
And just a couple of sort of flashcards that I kind of want to touch on before, again, we wrap. We don't have to delve too deep, but during the pandemic, did you see a lot of disputes coming to you with people having disputes with whether it be their landlords or whatever the case? What's your take on that whole last couple of years that we dealt with?
Yes. So during the pandemic, the landlord-tenant world just completely blew up. Tenants couldn't afford to pay their rent. Landlords, in turn, couldn't afford to pay their mortgages. We have eviction moratoriums that we're dealing with. When that was lifted, we have an overloaded court system when it comes to evictions. I think that's all been kind of smoothed out at this point, but it was really, really tough for a long while. And I understand the, kind of public policy or the reasoning behind these moratoriums and the protections for tenants that can't afford to pay their rent. But I did see a lot of tenants kind of taking advantage of that. They didn't have any job loss or wage loss. They didn't have any medical bills. They didn't really have any effect from the pandemic, but they were trying to get out of paying their rent or get out of paying it timely, knowing or thinking that they couldn't be evicted. And that put a lot of landlords in a tough spot because a lot of them depend on that rent to pay the mortgage. And they were at the position where they're either facing foreclosure or they have to rely on their bank to work out a deal with them. So it was a really tough time for both sides of it, I think. And yes, we saw a huge uptick in disputes and issues and people coming to us just not knowing what to do.
And that's expected. Who would you say was the more innocent side? Would it be the tenants or the landlord? Because obviously both of them were, well, not just them. Basically anybody with a pulse that has an entrepreneurial mind was trying to take advantage of all of the different things that came along with the pandemic. But in that case, where it was tenant versus landlord, who would you say sort of was on the right side in most cases?
So at the beginning of the pandemic, there was not really much guidance or specifics as far as when a tenant would qualify for waiver of rent or would fall under the eviction moratorium. As the pandemic, went on, we got more specified and more guidance as far as those things went. And so what we ended up with was you have to show that you've had a detrimental effect from COVID. You have to show that you've applied for rental assistance and you were denied. You have to show all of these things. And I will say the majority of the tenants that either I was representing in an eviction or that my client as the landlord was attempting to evict did not meet all of the requirements of that eviction moratorium. And so, in my experience through the pandemic, I think the majority of the tenants either they had no effect, they were just trying to take advantage, or they did have an effect from COVID. They just didn't know they had to jump through all these hoops and meet all these requirements in order to qualify. There were very few tenants that actually qualified and went through the proper steps and went through the proper mechanisms to satisfy those requirements. So that's what I really saw. And then we had judges, enforcing it, not enforcing it, loosely enforcing it. And so it kind of depended on which judge you got, kind of how it would go as far as whether they would allow the eviction to go through or not. So it was a huge mess. But to answer your question, I think the landlords for the most part were the ones that were abiding by the law and just trying to enforce their rights. And they were just having a very hard time doing so.
Understood. So real estate law is probably not for someone who needs something brand new every day. There's a lot of repetition, a lot of the same forms and stuff like that. So with that said, 20 years from now, if you're not retired from law, where do you see yourself? Do you see yourself still practicing law as a lawyer, or do you see yourself moving on to something different that would utilize all that experience? Have you thought about that at all?
I have, and I will disagree with you a little bit there, especially in my work with real estate investors. I'm throwing curveballs all the time. I see new creative ways to structure deals and do things. And so it is different, even though the underlying kind of legal principles are the same. But I do see myself running my law firm, but more as a CEO versus an actual lawyer in the law firm doing the legal work. I'm not burnt out from it at this point. I still enjoy it, but I can see a point where I maybe would want to, move into that more visionary leader type role. I hold all of the roles now, but kind of limiting the, hands-on day-to-day legal work role. I said earlier in the episode that I never saw myself as being an entrepreneur. I never really wanted to be one, but now that I am one, I really do enjoy that process and coming up with new ideas and trying new things in our firm and seeing how we can better serve clients. I really love that part of it at this point in my career. So if I could have 100% of my time be focused on those things, I think that would make me really happy, down the road 10, 20 years from now.
Awesome. MartinezLoveLaw.com. And her name is Cristen Martinez. We really appreciate you joining us here today. Welcome home. I'm Marc.
Thank you so much. It was such a pleasure being here.